Bonjour à tout le monde. Mon nom est Daniel Weinstock. Je suis le vice-doyen de la faculté à la recherche et je suis très heureux de vous accueillir à la faculté pour cet événement. I'd like to begin by noting that McGill is on land which has long served as a site of meeting and exchange amongst indigenous peoples, including the Haudenosaunee and the Anishinaabe nations. We acknowledge and thank the diverse indigenous peoples whose presence marks this territory on which peoples of the world now gather. Alors, c'est d'autant plus un honneur pour moi de vous accueillir pour cet événement consacré à la mémoire du juge Proulx, que par un tournant bizarre de l'histoire et de ma biographie, j'ai connu le juge Proulx assez bien while I was a junior professor at the University of Montréal, philosophy professor, no less. If I remember correctly, and we are talking probably a quarter century ago, the judge had arranged for me to be called to talk to his interns because he'd heard me on a radio show talking about some ethical question of the day and wanted me to talk to his interns about legal ethics. There ensued an intellectual relationship over the course of the next couple of years, which I cherished greatly as a junior faculty, being taken seriously by someone of the eminence of Juge Proulx, where we discussed issues of legal ethics and philosophical issues over the course of many meetings. I'd like to tell a couple of anecdotes which for me reflect both the spirit and the character of this remarkable man. In a flight of youthful overenthusiasm, I asked Juge Proulx to take part in an event that I organized in Trois-Rivières on the occasion of a Congress on the manuscript that he was working on, which became his book co-written with David Layton. And he accepted quite generously, but I had to drive him. We drove from Montreal to Trois-Rivières, and out of nowhere, a kind of freak late April, early May storm of freezing rain and snow and every kind of precipitation known to man and woman started descending from the heavens. And my only thought at the time was, I'm going to be responsible for the death of this eminent jurist as we drive through this terrible storm. But he was completely unfazed and continued discussing whatever issues of ethics and philosophy we'd been discussing as if nothing were happening. The other anecdote, as I was invited to this, I remembered an occasion where we were sitting on a panel to which he'd invited me, and he was talking about a case that presented ethical issues of great complexity. And as I was listening to him tell the details of the case, something rang a bell. And I realized about halfway through that he was actually telling the story of an episode of a show called Boston Legal, which had aired 2 or 3 days before. I kept a completely stone face, didn't say anything. But after the event, I said to him, Juge Proulx, you've been a participant in some of the most famous cases in the history of the Quebec criminal law. Why did you choose to appeal to a television show to sort of exemplify this story? And he looked at me with a smile and said, Vous savez, Daniel, des fois la télévision le fait mieux que la réalité. So it's a very great honor. I cherish, it was a very great honor for me to be able to have these discussions with Juge Proulx over the years, early in my career, and I cherish his memory very greatly. So the roundtable, which you are here for, is named after the Honorable Michel Proulx, who devoted his life to the improvement of the criminal justice system and to the advancement of human rights in Canada. He was called to the Quebec Bar in 1963. He quickly became known as one of the finest criminal lawyers nationwide. In 1989, he was appointed to the Court of Appeal of Quebec, and in 2006, he was awarded the Prix de la Justice du Québec in light of his devotion to the improvement of justice in Quebec. He equally taught criminal procedure and evidence in criminal matters for over 20 years as an adjunct professor here in the Faculty of Law at McGill, besides supporting our international human rights programs. His commitment to the Faculty of Law was constant and devoted, providing counsel and encouragement to students, teachers, and deans. The Faculty of Law hosts the Michel Proulx Roundtable conferences in criminal law to honor his memory. We're grateful to the Proulx family for making this event possible. So my job here is done, and I would like to introduce my colleague Mugambi Jouet, who really did the heavy lifting in bringing this extremely impressive panel together. And without further ado, I will ask him to come to the floor.
What is a human being? How should a human being be treated? How should a human being be treated when they have committed a crime? What do our answers to these questions say about us, about a society? The principle of human dignity in Western democracies and liberal democracies writ large is increasingly measured by the treatment of prisoners. If a society can recognize that even someone guilty of a serious crime possesses inalienable constitutional rights and human rights, that is a sign of that society's commitment to human dignity. This principle of human dignity has made tremendous progress since the Enlightenment, as illustrated by the gradual abolition of the death penalty. Yet, the situation before us can often appear dispiriting. Our prisons are places of despair for countless prisoners. The situation evokes a lack of ambition, a failure of the imagination, and endemic injustices. All too often, prisoners serve long sentences in violent and mismanaged prisons where they receive few opportunities toward rehabilitation, from educational programs to professional training programs, counseling, mental health services. For many, prison tends to exacerbate the behavioral problems or issues that led them to prison in the first place, if not maintain the status quo. And these harsh treatments are counterproductive. Most people who are in prison will be released someday, and society has an interest in their rehabilitation, which is key to public safety. But the inhumane treatment of prisoners also points to wider questions, wider inequalities. The people who are the most likely to be subjected to harsh, dehumanizing punishments are the most vulnerable members of society. Indigenous persons, Black people, racial and ethnic minorities writ large, and white people from underprivileged socioeconomic backgrounds. The issues of solitary confinement encompass all of these questions. The protracted detention of people in tiny cells, deprived of all or virtually all human contact, that crushes their spirit, or at least aims to do so. The human spirit is resilient, is increasingly recognized as not only a fundamental violation of human rights rooted in human dignity, but as a form of torture in violation of the United Nations Nelson Mandela rules on prisoners' rights. Yet, where there is life, there is hope. In 2019, two landmark decisions from provincial courts of appeal in Ontario and British Columbia found various facets of solitary confinement unconstitutional in Canada. Meanwhile, Parliament was in the process of reforming legislation regarding solitary confinement, which led to a new regime of so-called structured intervention units. And since then, a debate has mounted as to whether this new regime of solitary confinement, of structured intervention units, enables solitary confinement to persist in Canada. Our speakers today have been working at the forefront of these issues. They volunteered to assess data regarding the nature of solitary confinement in Canada and its reform movements. They faced countless setbacks, yet they are here today to present a key report. Our speakers are among the best of the best criminologists. They need no introduction to people in the field. They've published countless articles and books. They've testified before Parliament. They've been interviewed by the media, bringing light to key issues in light of their expertise. They've worked on a host of criminal justice questions, from punishment to juvenile justice, and now solitary confinement. I'm talking, of course, of Anthony Doob, Professor Emeritus of Criminology at the University of Toronto, and Jane Sprott, Professor of Criminology at Ryerson University. This debate over the future of solitary confinement continues here today at McGill, which historically has been a hub for thought about key questions of the day and the world of tomorrow. And this debate is not only being held here. Many societies are considering reforming or abolishing solitary confinement as a fundamental violation of human rights and human dignity. And perhaps one day, one country will be the first to abolish solitary confinement. And Canada could still become that trailblazer if it so chooses. And perhaps this will serve as a stepping stone towards a more effective, equal, and humane justice system. And that is why it is my fondest hope that tonight's event will stand the test of time.
Thank you very much for inviting us and for your very generous introduction. Jane and I are honored to have been invited to discuss with you in this year's Proulx Roundtable a variety of issues related to the practice of solitary confinement in Correctional Service Canada penitentiaries. In many ways, what we will be talking about will be issues that are analogous to the issues that the Honorable Michel Proulx is probably best known for, at least among academics, his work on ethics in criminal law. In his book that's already been referred to, he wrote, "Legal ethics is not an exact science, with every problem amenable to a set and indisputable resolution. What can be most frustrating about the study of lawyers' ethics is the elusiveness of a widespread consensus on many important issues." He didn't, as far as we know, examine the operation of our correctional system from an ethical perspective. But in preparing for this talk, Jane and I wondered what would happen if he had. Or more specifically, we thought about how he would have reacted to the ethical divide between Correctional Service Canada and virtually everyone who has examined their use of solitary confinement. One of the issues that unfortunately comes up fairly regularly in the operation of our correctional system is what happens when correctional service itself is in effect guilty of not following the law. Michel Proulx might have had something to say about this, if you will allow us to argue by analogy. He often gave advice on difficult problems. In writing about the inevitable conflicts that occur when lawyers find themselves defending the guilty, I think it's fair to say that Michel Proulx concluded that being responsible to the legal system as represented by the court must prevail over the interest that the client has in being found not guilty. Though he was more nuanced in his views, I think it would be fair to conclude that he believed strongly that the lawyer should not directly mislead the court. Corrections is different from the courts. It's not an open and public system. There's a reason why Michael Jackson, Canada's undisputed expert on solitary confinement for the last 50 years, entitled one of his books, "Justice Behind the Walls." But what happens when organizations like Correctional Service of Canada do not appear to take compliance with the letter and the spirit of the law seriously? Unlike courts, what goes on behind those walls typically cannot be examined. Jane and I have been trying for the past few years to find out what's happening in our federal penitentiaries, and more specifically, what's happening in Canada's segregation or solitary confinement cells that have now been renamed structural intervention units. Michel Proulx would, we believe, argue that Correctional Service of Canada has an obligation to be open and honest about what's happening in these regions of our penitentiaries. The story we'll be telling you today relates to the attempts that have been made in the last few years to shine a light on what's happening behind the walls. But we'll leave it to you to decide how Michel Proulx himself might have responded to the matters we'll be talking about. So what we're going to be doing is a bit of introduction where we give a little bit of a story of some events which happened 25 years ago to really set you up for understanding a bit about the general topic that we're talking about. We'll move on to talking about the legislation that created the structural intervention units, what was intended, the operation of the new law, which is obviously crucial, and CSC's response to the empirical findings on the implementation. We're also going to talk quite a bit about the oversight of the structural intervention units, or SIUs. There were two forms of oversight that we'll be talking about, and I think those are important in terms of understanding what's going on. The conclusion, what needs to be done, unfortunately, we're going to have to leave to you, because largely, although we have some thoughts on it, it will be something which takes some time to actually happen. The history I want to sort of start with is going back 25 years or so to what was known as the inquiry into certain events at the prison for women that Madam Justice Louise Arbour carried out in the mid-1990s. And I don't want to go into too much detail about it, but the chronology is actually important. That on the 22nd of April, 1994, there was an incident. Prisoners and guards were injured, there was violence certainly between them. The prisoners were separated and placed in certain cells, but the concerns about what they were doing continued for a few days. And between the 26th and 28th of April of that year, there were cell extractions going in, very heavily protected men going into these cells, pulling the women from the cells, cutting off or stripping the clothes off of the women, carrying out bodily cavity searches. And there was a video carried out of the whole process, as was the normal thing. There was some publicity about it at the time, and Correctional Service of Canada on the 3rd of May established a board of inquiry to look into what was going on. Now, the board was an interesting one. All of this comes from Louise Arbour's report. The board was an interesting one because the law at the time allowed for the board to include people from outside of Correctional Service of Canada. This particular board did not. It was Correctional Service of Canada employees only. There's no record of the information that they had. The first draft of it was was finished about 6 weeks later, in mid-June. And between June and September, there were 9 or 10 drafts of this report made, all from national headquarters of Correctional Service of Canada. There was a mention in one of the drafts, or in some of the early drafts, of the presence of the videotape. And in one of the drafts, there's a handwritten notation along the side which says, do we really have to mention this, or does this really have to be there? Clearly, the implication was we don't really need to advertise the fact that there is a videotape record of this. In June of 1994, the Office of the Correctional Investigator tried to get a hold of this videotape and was completely unsuccessful. And things sort of continued through 1994 until January 1995, the Board of Inquiry report was released, and it minimized the sort of talk about the cell extraction. The key inaccuracy, I would suggest, was that it implied that female staff removed the prisoner's clothing, and there was no real departure from basically law and policy. I mean, the departures which subsequently got to be known. CSC's account of this is interesting. I mean, their account of it was that, in effect, men did not strip search women. The description of one of these searches, for example, is she is stripped by female staff and a paper gown is put on by female staff. The same procedure is used on others. Same procedure, not necessarily identifying whether it was men or women who were doing this. There was another problem which occurred, which was the women were put in solitary confinement, and even then there were some rules about solitary confinement, that they were supposed to get an hour out of the cell for exercise and just basically to get out of the cell. And they were denied that until concerns were made by the Office of Correctional Investigator. Later on that year, Correctional Service of Canada retrieved the tape. They had said that, yes, there was a tape made, but it had been filed with some court material, or filed with the court with some other materials early on in 1994, and they said it was inaccessible to them. They didn't have a copy of it. But in December, they asked the court, and the court, of course, gave it back to them to make a copy, and they retrieved the tape. And in January, allowed the Office of the Correctional Investigator to look at this tape of the cell extraction. So this is the first time that somebody really from outside. Remarkably, it was only at about the same time that the Commissioner of Corrections, apparently for the first time, actually viewed this. So if you think of this potentially in terms of understanding and accountability, it's interesting that though everybody knew about the existence of the tape, though nobody had seen it until January of 1995, the commissioner himself didn't view it until the end of that month. Clearly they knew that something was going to happen. The minister was briefed in mid-February. The correctional investigator's report went to the minister and eventually was released. And in mid-February, there was a communication plan, and efforts were made to preclude the release of the tape. They knew clearly that this tape put Correctional Service of Canada in a very, very bad light. Also, they told mistruths about it. They had said that the tape showed that these searches were being done by women, kind of ignoring the fact that some of them were being done by men. So as Louise Arbour said, the immediate focus was entirely on preventing the showing of the video and damage control. And then, on the 21st of February of 1995, the Office of Correctional Investigator report was tabled with Parliament, and the Fifth Estate, the CBC program, the Fifth Estate, played it. They played it with blanking out faces where women had asked for that to be done. But it became a public issue, and it obviously became an enormous public issue. So what does this tell you? And why am we telling you, why are we wasting your time telling you about an old story? Well, I think, thank you. Sorry, yeah. The answer to that is that what we're going to be talking about are events which are occurring, but which didn't have the drama that this one did. This was the events in the mid-1990s were obviously quite dramatic. What we're going to be talking about with the structured intervention units is not as dramatic. But I think what you see and will be seeing is the importance that Correctional Service of Canada puts to the importance of protecting their own organization, of seeing what's going to happen to Correctional Service of Canada, and that really coming first. The control of information is something that we're going to be talking a fair amount about. The attempts in the end with the events that led to the Arbour Commission of controlling the information was unsuccessful. But the willingness to be less than fully honest and forthcoming is something that you will be seeing in our story, as well as you've heard about it with respect to the Arbour Commission. So the lack of concern about following the law is important. Louise Arbour, in her report, has one of these wonderful quotable statements, which is, the rule of law is absent, although rules are everywhere. So your question, I guess what I would like you to think about is, have things changed?
Thanks, Tony. So in the over 25 years following the incidents that Tony was talking about at Prison for Women, I think one sees both change and stability. There's change in the growing awareness of the harms of solitary and growing documentation of the problems with the legislation. As the lawsuits and court cases mounted over the years since the Arbour report, the writing has grown clearer on the wall that solitary confinement is an unacceptable practice. And during this time, in response to the mounting bad press and growing number of lawsuits and court cases, CSC itself documented reductions in the number of inmates who were officially being held in administrative segregation. And all of this suggests change, that solitary was becoming broadly unacceptable to the point where even CSC understood that. And finally, more recently, between 2017 and 2019, the federal legislation authorizing administrative segregation has been declared unconstitutional by both trial and appeal courts in Ontario and in BC. Now, Lisa Kerr has a fantastic documentation of the important differences in details between the trial and appeal court decisions and between the Ontario and BC appeal cases. But those differences aside, although different analytic paths were taken, the decisions ultimately rendered the legislation unconstitutional. And rather than see these cases go to the Supreme Court, the government decided to write new legislation to abolish solitary confinement, essentially circumventing the need to go to the Supreme Court. So Bill 83 was introduced in 2019 and became law in 2019, and it was hailed by the government as effectively abolishing solitary confinement. Importantly, written into law was a minimum of 4 hours outside of the cell, 2 hours of which had to involve meaningful human contact. This was a crucial baseline because it set it apart from the UN Mandela Rules definition of solitary confinement, which defines solitary as 2 hours or less out of cell. So with this new minimum of 4 hours, it wasn't solitary. Indeed, this new regime appears to offer a variety of supports and opportunities, a far cry from what anyone would think constitutes solitary confinement. And perhaps this all speaks to change. But I warned that there was stability too. And as Tony described, the institution implementing this legislation, CSC, has a long history of pushback and opacity. As others have noted, this institution tends to bend against the law to stay true to its core. And issues around rights tend to be grafted on afterwards if they're administratively convenient. A number of the more recent court cases have continued to note maladministration by CSC, which sounds very reminiscent to what Arbour was finding over 25 years ago. So while the legislation provides the framework, it all comes down to how CSC will administer the law and attempt to animate the underlying features of it. And sadly, this may be where stability reigns. The first look at how these new regimes were functioning raised serious concerns. To give a sad overview that most people are probably aware of, there is extreme Indigenous overrepresentation. While Indigenous people are estimated to account for about 5% of the Canadian population in 2016, they more recently account for 32% of the federal custody population and almost 49% of the SIU population. And we show you Quebec too, as it shows similar overrepresentation. And to continue with the focus on Quebec, we should note the number of institutions in this province. In terms of the number of federal institutions, federal prisons, and the number of SIUs, Quebec is rivaled only by the 3 combined prairie provinces. By comparison, Ontario, with a much larger adult population, has 1 SIU, not 4 of them. So perhaps not all that surprising then, since Quebec has so many SIUs, the province has a relatively high rate of use. Expressed as the number of SIU stays per 1,000 prisoners in the region, one sees that Quebec has a very high rate of short stays that we're defining as 15 days or less. It's almost 2.5 times the overall Canadian rate and over 9 times the Ontario rate. Although not as dramatic, Quebec also has a relatively high rate of longer stays too. And looking in a little more detail at the length of time spent in SIUs raises a couple more questions. First, one sees the rather dramatic variation here between Ontario and Quebec. Over 1/3 of Quebec stays are only for between 1 to 5 days, compared to Ontario, where only 14% are that short. And second, although there's an explicit statement in the legislation that the inmates' confinement should end as soon as possible, overall in Canada, a little over half are lasting longer than 15 days. So what about achieving the minimum of 4 hours out of cell? Again, we see enormous regional variation in achieving this goal. Ontario perhaps stands out as the better region among these 3, with only 6% of stays missing their full 4 hours out of cell every single day of their stay. And this is looking only among the longer stays, so those stays that are 16 days or longer. So Ontario, with only 6% missing every single day of their 4 hours, that stands in contrast to Quebec, where 22% of stays are missing their full 4 hours every single day. And the Pacific region, where 42% are missing their full 4 hours out of cell every single day of their stay. Overall, across Canada, 77% of these stays are not receiving their full 4 hours out of cell in over half of their days. And they aren't missing their full 4 hours by minutes. Remember, the definition of solitary, according to the Mandela rules, is being confined to a cell for 22 hours a day or more. And if that confinement lasts longer than 15 days, it's considered cruel, it's considered torture or other cruel, inhumane, or degrading treatment. So using those definitions then, overall, we see that 28% of these stays in Canada would fit into the definition by the UN Mandela rules of solitary confinement, and another 9% would fit the definition of torture. Again, though, I draw your attention to the rather extreme regional variation illustrated with Quebec and Ontario here. And a common response to these failures to meet the minimum legislated 4 hours out of cell is that the person refused to leave their cell. Now, importantly, we have no idea what is being offered to people, nor why they decline. So in other words, we don't really know what it means when someone refuses. It doesn't perhaps, though, take much creativity to consider some scenarios where one may well want to refuse what is being offered. Regardless, refusals to leave are not what's driving these failures. Looking at those who missed every single day of their full 4 hours, that is, on the longer stays of 16 days or more, and every single day they never received their full 4 hours, 26% of them only refused to leave in 20% of their days. Another third refused in less than half their days, yet they missed every single day. So among that last row who's missing every single day, 58%, the majority who missed every day, refused in less than half of their days. So why did they miss every day? Again, however, there's enormous regional variation in these refusals. On this metric, Quebec looks better than the Pacific region. Less than half of those in Quebec refuse to leave their cell in over 20% of their days, compared to 69% in the Pacific region that are refusing that much. So with all of this evidence of the concerning failures around the implementation of this legislation, what was the response from CSC about these findings? Well, perhaps predictably, the public response was somewhat vague, noting that they're committed to change and working on it and taking it seriously. But perhaps and more important, they highlighted the new independent oversight, 2 bodies of independent oversight that existed. The Implementation Advisory Panel, which they note Tony chaired, and independent external decision makers, IEDMs, who review individual cases. This was reiterated again 6 months later on CSC's website. Now, CSC's repeated mention of these 2 oversight bodies during 2020 and 2021 was perhaps important and telling. It was maybe important for CSC to communicate that whatever issues are going on here, to some extent, don't worry, because all of this has been reviewed by 2 independent oversight bodies that have been designed specifically to monitor SIUs. We have the Implementation Advisory Panel, chaired by Professor Doob, and we have individual SIU decisions being reviewed by these independent external decision makers. But CSC's repeated mention of these 2 oversight bodies may also have been somewhat telling in what they thought about oversight. And given that CSC mentioned that Tony chaired the IAP, the Implementation Advisory Panel, I'll now turn the floor back to Tony for a closer look at the oversight that CSC claimed existed at the time.
Without trying to take away the surprise from all of this, the surprise is that I was on that first panel. I was asked to, subsequently, I was asked to chair that first panel, which was set up in the summer of 2019 before the legislation came into place. And you will be seeing that we accomplished essentially nothing in the year that that first panel existed. But let me tell you the story. So we were appointed, there were 8 of us, we were appointed over a period of a couple of months during the summer of 2019. And in the fall of 2019, we had a meeting. The first meeting was set up by Correctional Service of Canada to essentially brief us about what they were doing and how they saw the legislation and their various rules that they were developing at the time. And then we, the panel, had a subsequent meeting where we effectively created a work plan for what we were planning on doing, how we were going to go about doing things. And one of our plans, this is again, just at the time that these structured intervention units were opening, one of the important parts of our plan was to try to get a kind of overall picture to see where we should be putting our resources. We were appointed for a year. That's not a very long period of time for a major change, to look at a major change in a big institution like Correctional Service of Canada. So we thought, well, let's look at the administrative data. Let's look carefully at the administrative data ourselves, see what the issues are, see where we have to look at, where we have to look further, and then we can go about trying to plan our year of examination of the structured intervention units. So in November of 2019, a few weeks before the units were actually opened, we, the panel, gave Correctional Service of Canada a detailed list of what we wanted, and in fact, the form in which we wanted it. For those of you who use Excel, it was essentially, we were asking for an Excel file which had on it each of the prisoners, each of the stays for each of the prisoners, as different rows, and a whole bunch of characteristics about the prisoner and about the stay across the columns. It was a sort of obvious way to get data about prison stays. We asked for that in November. It was acknowledged by Correctional Service of Canada. They saw no problems with it, and they certainly challenged nothing about it. But the plan was that we were supposed to be getting these data at the end of February. We were supposed to start getting the data, I should say, by the end of February. And we said, look, we have a short period of time. We want to find out things really quickly. So give us the data from what's happening in essentially December and January. Give us those data by the end of February, and then we can start figuring out how we're going to use our time effectively. We were, as was mentioned earlier, a volunteer panel. There were 8 of us, all volunteering our time. We weren't paid by CSC. And so we expected things to go along, and then we were, in a sense, preparing for getting these data at the end of February. When February turned, when we came into February of 2020, I realized that we didn't have any procedures set up about how I was going to get the data and what the security concerns were. Correctional Service of Canada has legitimate security concerns about these kinds of data. So I called my contact at Correctional Service of Canada and said, we have to work on or figure out how these data are going to be transferred to me. What the rules are on working on them, but basically, how are you going to get me the data? And I was told in that first telephone call that they weren't sure that they were going to give me the data. Now, I have a 10-year-old granddaughter, and when I ask her things like, are you going to eat your vegetables? She says, Grandpa, I'm not sure. Now, it didn't take me long with my granddaughter to realize that's a no, Grandpa, but I'm trying to be polite about it. And I guess I kind of knew that in February of 2020. And the panel that I was chairing expressed its concern about this immediately. We're looking at the summer of 2020 as the end of our period of time of oversight. We could be reappointed, but that was the period of time we were supposed to get something done. And we're looking at that in February and saying, we don't have time to screw around. And so we expressed our concern immediately, and on the 15th of March, having not heard anything, we, the panel, wrote to Correctional Service of Canada with a copy to the Commissioner saying, we need to know what's going on, and we need to know within a week about what's going on. Because every day at that point was really counting. We were looking at the summer as having to find something useful for understanding what was going on in these units by the middle of the summer. So we wrote, and we asked for a reply by the 23rd of March, and we didn't get a reply by the 23rd of March. So we wrote again on the 30th of March, except this time we upped it a little bit, and we wrote to the federal minister who was in charge of corrections, Bill Blair, Minister of Public Safety, and said, essentially, the current situation's untenable. We're not able to do our work. You have a panel that is unable to do its job, and we need some assistance in this. We need you to get involved, or we need corrections to get involved. We agreed, because there was discussion among the panel members, we agreed that that we would be confidential about this for at least a month, because we wanted to sort this thing out. I mean, I think there were some people on the panel who didn't believe that what I was told was just like my granddaughter says, but that we would actually get the data. And so, so we said, we'll be quiet. We emailed that to the minister and with a copy to the Commissioner of Correctional Service of Canada, and got an immediate reply from the commissioner. I mean, within an hour or two, from the commissioner saying, Tony, we need to talk. And I wrote back and I said, yeah, we do need to talk. I'm happy to talk anytime. And there were some, her life is much more complicated than mine. I said, basically, anytime you're ready, I'm happy to meet. And there were some appointments that were made that for reasons largely on her side had to be canceled. But by the end of the month, we actually did have a telephone conversation about what was going on with the panel that I was chairing, which had accomplished nothing. One of the surprising things to me was that here we are in April. We had made our request in November, and she started questioning why we needed the data. I think I was polite. I didn't use very rude words. But what I said is, how are we supposed to accomplish what we're supposed to accomplish if we don't know what's going on? And her answer to it was, well, we're very happy to share with you any policy documents and things of that sort, but I don't understand why you need the data. And I said, you know, I thought that it was pretty clear because we need to know what's actually happening. We understand the policy, and we understand how complex the policy is, and we understand your challenges. Now, what was also interesting is I never got any reply from the minister's office at this time. So the letter was written to Bill Blair as minister. We never got a written reply from his office, and I never really heard from him until August. But anyway, to her credit, the commissioner went away, and on the 8th of May, agreed that there would be data, but there was no date set for the delivery of these data. We said we need to know when you're going to get these data to us because we need to get to work. We'd been hoping to be getting to work in February. It's now May. We need to know what's happening. And in the middle of May, we were told that some data is possible. And on the 27th of May, we were told the data were available to us. And I just had to drive across town and pick them up at this very peculiar parole office in a strip mall in Toronto next to an Irish bar. So I went over to pick them up, and I knew what I was expecting. There might be some explanatory materials, and then I was expecting this file full of data. You could say that there might have been 3 different files, but basically a file full of data. And this very helpful person in this parole office said to me, Tony, what are you expecting? I said, I don't know, 2 or 3 files. And he said, you're getting hundreds of separate files being downloaded, because we were downloading them at his place. And I said, really? And he said, yeah, I don't know how many hundreds, but hundreds. So I said, okay, fine, let's just download them all, and I'll take the computer, this new computer that they'd given with, you know, all of their security things, I'll take it home and I'll try to figure out what it was. And I get home and, you know, I did an estimate, and I realized that there are over 900 separate files with text material in them and some numbers and so on. And I think if I'd spent a lot of time, I could have figured out at least what it was I might have received, because the explanatory material told me nothing. Anyway, I called up Correctional Service of Canada that afternoon. I said, this isn't what we asked for. And they said, and I explained what I'd asked for. It was all on a written document. And I explained what I'd received, which is over 900 separate files, which were completely unanalyzable. And they said, okay, we'll work on it. And during that time, it was a very interesting change that I was enormously appreciative of. But Correctional Service of Canada put a person on this job who was extremely good. When there was a problem, she went through, first of all, she said, I have to see what you've given, I have to see what you've asked for, and I have to see whether there's any way that we can get one from the other. And then, she called me back shortly thereafter and a few days later and said, look, what you've gotten is not useful. It's not a good starting point. It's not going to be useful for your purposes. There's various problems of not knowing when these data were extracted and what they actually mean. We have to start over. And I said, well, fine, that's good. We know what we're starting with. And then subsequently, there would be similar kinds of telephone calls where she would say, Tony, you've asked for this. That's going to be really hard for us, but we can give you that, which is pretty close. I mean, an example was I asked something about criminal record, and she said, we can get you the number of times the person has been admitted and on a new warrant to Correctional Service of Canada. That's real easy, but getting anything more is going to be very difficult. I said, that's fine. That's all I need. So she was looking for compromises that would allow us to get the data really quickly, and was just extremely good. She asked very intelligent questions and was completely open with some things that were just very difficult to get or weren't being collected. So she told me all of that. And then time went on, and she sort of faded out. And I'm not blaming her in the slightest, because she works for an institution and worked for an organization, and all of a sudden we weren't getting, things didn't seem to be progressing, and furthermore, our time as a panel was running out. We're in the middle of the summer by now, and we as a panel decided, okay, it's time to do something. So middle of July, we have no data, no estimated delivery date, and we decided we have to write our final report, and we have to just describe why we were unsuccessful, why we'd wasted a year of our time getting absolutely nowhere. I'm not embarrassed in saying that, because I do think we could have gotten somewhere had we gotten cooperation, but we would have gotten nowhere, and people were expecting things. There was a lot of concern about solitary confinement, and people were expecting that our panel would actually do something. So on the 11th of August of 2020, we finished our report, and we sent a copy to Correctional Service of Canada as a courtesy. And we got a reply from them which said, well, yeah, sorry about the data, but we'll give you monthly updates. We hope to get you something by the end of the year. We'll give you monthly updates on the progress in getting the data to the panel. And so we released our first and only annual report, because by the time we released it in August of 2020, we as a panel actually did not exist. Now, completely by chance, I didn't think about this. I promise I didn't think about it. We released it on a Monday, and we sent it to various people who we knew, because they've been writing to us, had a real interest in this. And the lack of findings was itself a story. It was a fairly big story in various media things. And very quickly, I got a telephone call from somebody in the minister's office, and then subsequently from the minister himself. It showed up private, and I was almost rude, thinking it was a telemarketer, but it turned out to be Bill Blair himself calling. And anyway, I got I talked to people in his office, and Blair did call me, and we had a long discussion about this. And he said, look, first of all, I want to extend the panel. I didn't know the panel was running out. Nobody briefed me about this. I didn't know this, and I didn't know any of the problems that were happening. I don't know what happened to the letter. But he wasn't absolving himself of responsibility at all. He was saying, this is my responsibility, but we obviously screwed up. So will you stay on if we extend the panel? And I couldn't speak for the panel. There are 7 other members. I couldn't speak for them. But what I did say was, and my position is, I'm not even going to think about this until we get some information. I've been jerked around for a year, and I'm not going to talk about it. I'm not going to think about it until I actually know we can do anything. And so I talked to Blair about getting the data, and he essentially said, let me see what I can do. And very quickly, obviously by because the minister said something should happen. Very quickly, remember, we were supposed to get monthly updates. 30th of September, we get the data. I get a call, the data are there, magically. The data, that's what happens when ministers apparently have magic. So there I am on the 30th of September with the data, and I'd worked with Jane for 20 or 25 years on various kinds of projects using all sorts of different kinds of data, court data and correctional data. And I thought I should tell the minister's office that I was going to work with Jane on this. And I called them up and I said, oh, by the way, I'm going to be working with Jane Sprott on this. And if there's anything you need from her in terms of security clearance and so on, you better get it quickly because we're starting this afternoon. And they said, oh, can you do that? And I said, no, I'm not asking. I'm telling you. We're going to be working on the data. And they said, oh, okay, fine. I guess that's okay. So we're then two completely independent. We had no relationship. The panel didn't exist. I never had an employment relationship or a paid relationship with Public Safety or Correctional Service of Canada on this thing. So Jane and I started work on this data. It's the 30th of September in the afternoon. We actually get the data. And we decided that this was something that was important. People had been waiting a long time. And we had, remember, in my mind, I'm thinking, well, this is stuff that we should have gotten, or part of it we should have gotten in February of that year, of 2020. So we want to show that this could be done. And so Jane and I worked on it, not like 24 hours a day, but we worked on it fairly steadily for 17 days, and we completed our first report, which we then circulated again amongst a bunch of people who knew about solitary confinement, structural intervention units, and also to Correctional Service of Canada. And with Correctional Service of Canada, we gave them a deadline, which they almost met but didn't quite meet. And on the Saturday night, Jane and I refer to as our Saturday night email. On Saturday night, we received an email from Correctional Service of Canada, which said, yeah, there's some problems in the operation of the structural intervention units, but it all has to do with COVID. And in any case, your data are flawed because there's some problems with the data. And again, Jane and I refer to this as the dog ate the data excuse on the part of Correctional Service of Canada. But all of a sudden, we're getting this. So we released the report. We released, including the report, we released their reply to us, the email exchange between us and them, so that everybody could see the whole story. And we released it on the 16th of October, which again was a slow news day. We don't have some magic to pick slow news days, but we apparently did for these first couple of things. And again, that release got a fair amount of publicity. And again, there were talks about renewing the panel. So the talk about renewing the panel was seen by various people as a way of kind of getting things back on the rails. So the renewing the panel started in August, and renewing the panel again came up in October. And by October, I personally realized that I'm perfectly happy to be on another panel, to be on panel number 2, but I'm not going to chair it. I've had it with that. And it probably in terms of the operation of the panel, it would be better to get a new chair. In any case, I didn't want personally to do it, and I thought somebody else could probably do a better job. So this is October 2020. There's a concern. This is oversight. As Jane's already mentioned, this is one of the 2 key links in terms of oversight. It's important to have this panel looking at things. The IEDMs are looking at individual cases. You are the panel looking at things. That panel was established in July of 2021. I have no idea why it took that long. Well, I think if you go back and look at things a little bit more carefully, you understand a little bit about oversight of these structural intervention units specifically, or of Correctional Service of Canada more generally. Remember, as Jane has already said, Correctional Service of Canada and the government did not want to change the legislation. They were pressured. They knew they could see the writing on the wall from the court cases, and they knew what was happening. The original legislation was really interesting to go back and see and go back and read after all of these things, because the original legislation did not have any mention of the independent external decision makers. The message, in a sense, was we don't really need external people. There was a provision about registered health professionals employed and engaged by the Correctional Service of Canada can recommend to the institutional head that the terms of a person's stay in an SIU can be changed, and then the institution head shall determine it. So what kind of oversight is this? That an internal person can recommend and a person above that person can essentially decide. That was what was in the original legislation. When the minister introduced the legislation at second reading, he talked about this. He said, you know, the medical professionals working in the correctional system must be free to exercise their professional judgment autonomously on the basis of their own medical expertise. But again, think about what that means. If you're an employee of the institution and you're going against other people in the institution, how independent are you really? Now, the IEDMs are a different matter, and the IEDM legislation is really an interesting one in terms of obscure writing of legislation. And we've put on this slide sort of the time frame on this. But if you go through this, and I won't go through it in great detail, but what you see is that a staff member starts, an institutional head looks at it, there's reasons have to go back to the prisoner, there's a health review, then the institutional head determines whether the person stays in the SIU. Eventually, at step 6 in this, the commissioner decides if the prisoner is supposed to stay. I should point out that the regulations and the commissioner's directives mean that other people other than the commissioner herself can actually decide if a person's supposed to stay. But that is going to the commissioner at day 66 to 68 as far as we can figure out. And if the commissioner decides that the person's going to stay, then at that point, day 66 to 68, it goes to the independent external decision makers who does have the power to actually decide what's going on. Now, I want to make it clear that our concerns about this process have to do with the process, not the people who are doing it. If you look at the independent external decision makers' backgrounds, they are people who any of us in this room would have chosen and been extremely happy had they been chosen for this job. The concern isn't that. The concern is the structure in which they have to work. And when you go into the legislation and carefully, you see what the problems are. You see that basically the advantage is set up for corrections itself. The ability of the prisoner to make a case is very difficult, not, again, because of any difficulty with the decision makers themselves, but just simply the way in which it happens. Correctional Service of Canada shall furnish these decision makers all information under the service's control that's relevant. Who decides what's relevant? Well, Correctional Service of Canada decides what's relevant. The decision maker may require any kind of information from Correctional Service of Canada, but to require it means you have to know about it. You have to know what's there. You have to know that something's there in order to ask for it. The decision maker shall provide the prisoner in writing the information that's considered by the decision maker or a summary of that information. Now think about that. Your life, your decision about whether you're going to be in solitary confinement is determined. You're going to get a summary of that information. Unless, of course, it's in the public interest that it not be given to you. Well, that's a pretty open thing. And of course, corrections has the ability to convince you, perhaps, that it's in the public interest to withhold that information. The prisoner can answer, but the prisoner has to answer, or prisoner is only guaranteed that the prisoner can answer in writing. So you have Correctional Service of Canada with its 20,000 employees, and you have a prisoner who may or may not have independent counsel who can reply in writing. Decisions may be published. Decisions aren't automatically published. In fact, it's very difficult to get to see these decisions. So we really don't know what's happening in this whole process, not because of the people who were appointed, but rather because of the structure that's in the legislation. The legislation essentially precludes the possibility of what you in a law school would normally think of as a full, fair process.
Thanks, Tony. So to continue on, Tony's highlighted obviously this really concerning, somewhat opaque and confusing legislative framework that the IEDMs have to work with around deciding length of stay issues. And as we were reviewing this framework, we couldn't help but wonder what Justice Proulx might have thought of that process, given his 1983 paper on the necessity of having the accused at trial. Given the manner in which these decisions are made in the absence of the prisoner within this legislative framework, and given Justice Proux's argument that the right to be present should be invoked whenever there is a possibility that, due to his absence, the accused's right to make full answer in defense has been infringed, one wonders if he might have found this process problematic or even offensive. And while CSC might argue that these decisions around length of stay don't really involve punishment because they're focused on treatment and they have access to treatment, the actual operation of these SIUs suggests more of a rebranding of solitary rather than an abolition of it. So given this problematic legislative framework, these next set of findings probably won't surprise anyone. As Tony mentioned, since all of the information basically comes from CSC, holding all of that, it's perhaps not surprising that the majority of decisions are to maintain the status quo. 59% of the decisions made by IEDMs were that the stay should continue. Though I draw your attention to the rather large proportion, 30% of cases that were sent to an IEDM, but were ultimately transferred out before that decision was rendered. And given that we have no idea really what information is sent to IEDMs in order for them to render their decision, it's also perhaps not surprising that there's significant variation across IEDMs in their decisions. Some IEDMs have never rendered a decision to remove an inmate, while others said an inmate should be removed in 41% of the cases they saw. The decision to remain in was rendered in 37% up to 86% of IEDM cases. And of all the decisions to remove an inmate, 39% of them came from one IEDM alone. Also interesting, an IEDM decision to remove an inmate from these SIUs appears not to get them out any more quickly than a decision to remain in. Of those where the decision was to remove the inmate, 27% took over 60 days after the IEDM rendered that decision before they were removed. So it took another 2 months after that decision came down. Only 4% of those with decisions to remain in stayed that long. How is that possible? Well, the Commissioner's directives might provide a clue. While transfers out of an SIU into the general population are to happen immediately within an institution, if the inmate needs to be transferred to a different institution, they can simply wait in the SIU until such transportation is arranged. So this could help perhaps explain another perplexing finding, that there are cases that have been in SIUs long enough to trigger an IEDM review, but they were never sent for one. At the most extreme example, 137 of these SIU stays ended up being longer than 120 days, so longer than 4 months. And 35% of them were never sent to an IEDM to be reviewed about their length of stay. So we reviewed one of these cases, or we reviewed a number of cases trying to understand how this might happen. So one such case is Larry. My eyes aren't good enough to see that screen. Larry was an Indigenous man in his 50s. He was serving an indeterminate sentence for an offense against a person. He's been a prisoner with CSC for over 20 years and has had more than 20 stays in segregation before they changed to the SIUs. In the first year of operation under the new regime of the SIUs, he had 5 separate stays. The reasons for the stays varied. Safety and security of the institution are related to his own safety. At his 5th SIU stay, CSC indicated that he had mental health issues. It was his 2nd stay in the SIU that lasted longer than 4 months that was never sent to an IEDM. And during this stay, he never once received his full 4 hours out of cell, and in 96% of the days, he never received his 2 hours of meaningful contact. The stay ended, however, with a transfer to an institution in a different region. And the mental health issues that appear at the end of his SIU stay, where we have information for him, I don't know if that's a slow recognition of mental health issues or perhaps the worsening of mental health issues over time, but we see that in other data. By CSC's own measure, they see that someone's mental health is deteriorating, yet that SIU stay continues. Of those with deteriorating mental health, we see that 37% stayed longer than 62 days, compared to only 21% of those with no deteriorating mental health, as assessed by CSC. So what has CSC's response been to all of this? Not only all the evidence of serious problems with the administration of this legislation, but also with the framework for independent reviews by these IEDMs? Well, basically nothing. So where does that leave us? Well, we wanted to accomplish short stays, but there's no real standard and no time limits for them. We wanted time out of cell and true independent oversight, but we seem to be accomplishing neither one. And of course, the concern is that as the focus and pressure sharpens on these SIUs, if there are true improvements in getting time out of cell and shortening stays, which we hope there would be over time, then we're really left wondering what's happening elsewhere in these institutions. Because, of course, solitary is a practice, not a place. And it would be easy for that practice to slip into the darker corners of the institution, which have limited meaningful oversight. In other jurisdictions similar to ours, there's a reason why prison inspections are not announced ahead of time. And to come full circle back to the history that Tony highlighted at the beginning, the story of solitary over the decades tells a very consistent story of an organization, Correctional Service Canada, that does not see itself as accountable to the rule of law, bending and pushing against legislation that governs it, and being overseen largely by governments that let it do whatever it wants. So the real problem in the end may be, does anyone actually care?
Now we get tested?
Now we fail.
Thank you so much for this compelling presentation. We have 40 minutes or so for a Q&A. We have microphones on each side of the room, please speak at the microphone if you have to ask a question so that people online are able to hear your question.
Hi, thank you very much for your presentation. I learned a lot. I'm just curious if you know anything more in detail about what constitutes meaningful human contact in the context of a prison stay and a prisoner who's been placed in an SIU. Thank you.
The short answer is no, not really. We don't know what's constituting that or what they have in place for that. I guess my own feeling is that since they're not really meeting bars about the 4 hours out, that would be a problem to think about more carefully if you were meeting other bars first. But it's a great question, and we've wondered about it. I don't know if you have any.
I will say the same thing as Jane, but in slightly different terms, which is that I think there's a broad problem of knowing what these categories mean, because it's easy to go to the commissioner's directives or to that. There's a slide which we can give you on which is taken from the web of kind of what meaningful human contact is. And it's basically that it's not just being out and watching television, but something more than that where you're actually having an interaction. The problem is, and we didn't get far into it because it's very difficult, it seems to me, to have much confidence in the coding of what that meaningful human contact might be unless you have a sort of fairly good idea about what it is that you're looking for and whether this is it or not. And so if it's just any kind of contact, if it's playing card games with people outside, then fine. If it's playing card games with people outside, then we should know that. But we shouldn't think that it's something grander than that if it's just playing card games. And we have this repeatedly with these administrative data. I mean, these administrative go kind of that deep into what's going on in these units. And so, another issue that Jane made reference to was the issue of refusals. I mean, one of the issues, this, as I said, I'm expanding your question, but refusals are the same problem. I understand that people will refuse to want to leave the cells for various reasons. And that makes a lot of sense to me. Sometimes I just don't want to see people. I want to be alone and so on. That's fine. The problem is we don't know what they're refusing. And we don't know why they're refusing. And we've, as a sense, as a society, we've said getting out of cell and having the meaningful human contact is important. But if the reason the person's refusing is that they're afraid that somebody else is going to beat them up, or I was talking to one person, and I said, have you ever refused? And he kind of rolled his eyes at me, and he said, of course. And I said, well, tell me about one. He said, well, I refused for weeks because I was offered that I could go out into the yard and exercise. He said, there are no exercise machines out there. I was given this lousy little thin jacket, and it was -40. He said, I didn't take it, so I'm probably listed in your data as a refusal, which he said I was. So, so that's a refusal. And there may be other people who are refusing because they're nervous, because they're facing challenges of various sorts. I think that these kinds of problems are really the things that need to be done. The short answer to your question is, as Jane has already said, we don't know. But it's also very important that we know if this is supposed to be a meaningful experience for people, and remember, that most of them are going to be getting out. So it's in everybody's interest, and especially theirs, that this be a positive experience. But it's in our interest as well. We have to ensure that these things are meaningful and are real. And that's a lot of work. I mean, Jane and I are dealing with the administrative data, which, as I said, are broad but very thin.
I actually have a follow-up question. Could you speak to the psychiatric and mental health problems that are caused by these protracted stays in solitary confinement? You alluded to this, but could you speak further to these medical issues?
There's a lot of research. It's very difficult research to carry out, but there's a lot of research over many decades about the harmful effects, cognitive, emotional effects, psychological effects on people of isolation. And there is as well, just to warn you, some literature which suggests that these sorts of things aren't harmful. And there's been some critiques. If any of you will email you, I can send you some of the references to it. There's some critiques of the research which is suggesting that it's not very harmful to people. And the problem is that it's this is very difficult research to do at the best of times. But if you're doing it in a setting where they aren't terribly sympathetic to research, or you're doing it without appropriate kinds of comparisons, then it's very difficult to infer what's going on. I mean, there's no perfect kind of randomized experiment being done on solitary confinement, but the data overwhelmingly from, perhaps somewhat flawed study after flawed study is that this is not part of normal human activity and normal human interaction. I mean, there was a thing I read somewhere, and it may have been in our BOR, which is if you had somebody who was suffering a mental illness and mental problems and having difficulty emotionally, difficulty cognitively, would you send her into a room that was 8 feet by 10 feet and had no contact with human beings, and people were being, there was absolutely minimal contact? And the answer is, of course you wouldn't. You would in fact try to do the opposite. Even if that person were to resist, you would try to engage them, you would try to involve them in normal human activity. So, I mean, it's not terribly surprising that the clinical evidence is that it's not a very good experience for people. That said, you can easily understand, I think, why it might be necessary to have a place where you can put people for a day or two while they're sort of cooling out and getting over something or whatever they might be doing. So that I can easily understand short stays, and short stays that really do end in a short period of time. In a sense, we've all had that, where we say, I just have to get away from people. We've known people who have done that, and they go away involuntarily, and then they come back and things. So I can understand that. But it's when you start saying it's going 30, 60, 90, 552 days, I mean, then you sort of begin to worry about what's happening.
One follow-up question is that a key issue for solitary confinement in different societies is that it's often used or at least invoked as a way of treating prisoners who are either perpetrators of violence within the prison to isolate them so that they cannot victimize other prisoners. And by the same token, it's also used or invoked as a means of protecting victims among prisoners who themselves may be targeted by other prisoners. So it has this peculiar characteristic of being used to segregate for very long periods, if not indefinitely, both alleged perpetrators and victims. To what extent has this been part of what you've seen in your research, this dynamic and the use of solitary confinement?
I don't know that we can see it very well in the thing. What we have are some basically legislative codes as to why people are there. for their own protection, for the security of others, and for the kind of broadly because there's some security issues related to that person in the institution. But understanding, I think what you have to do really to answer your questions is you have to understand what the choices are. And I mean, I can understand from a kind of bureaucratic perspective, the easiest thing to do with somebody who is troubled or a troublemaker or at risk or risking others is to put them in a room by themselves and lock them up and forget about them. I mean, certainly from a bureaucratic perspective, that sounds easy. We have a very expensive correctional program at the federal level. I mean, these cells are costing probably hundreds of thousands of dollars. A maximum security prisoner is costing something like $120,000 per year to house. We have an expensive system. What we need to do is have an imagination about how to deal with difficult problems. I mean, throwing away difficult problems isn't very helpful, especially because people are going to get out, they are going to be on their own, they are going to be back amongst us in society, and we are going to be dealing with them.
Yeah, and just to follow up on that too, like that's obviously, you know, we hear that, you know, it's a way of managing the more difficult people, but it's also frustrating because this isn't a new issue. So like to Tony's point, really there's been no imagination, no innovative thoughts on how to deal with, like, newsflash, people that are housed in these institutions can be difficult people. Well, how it, like, just, it's never addressing it, never doing anything since the first lawsuits came out in the 70s, and it seems like they're still, well, these are difficult people to manage, we don't know what to do, and it seems really astonishing to me that there's not more movement on actually solving the problem, like Tony said, where instead it's just get it away, what's the quickest solution, and not a solution, just get it away.
I think I'm correct in this, which is the last line of the description of the person who we gave the name Larry to, was that the stay ended with a transfer to an institution in a different region.
Yeah.
Well, I mean, that's an admission of failure like you've never seen before, which is the best thing we can do is to try to, you know, pass him off to somebody else, and maybe they can do something. That's not a very good solution from anybody's perspective. Also, Larry probably has family or people, contacts somewhere in this country. And if you're moving him from region to region, then this is not a very productive way of dealing with perhaps a very difficult person.
Mm-hmm.
Good evening. My question for you is, after all your interactions with the CSC, what do you think makes them so, I guess, slow and reluctant to change even by public service standards, and to not even be willing to engage in like good faith discussions or interactions on how to reform, I guess? Thank you.
I'll let you take it.
I think that the reason is that decisions are made in a very short time. I mean, if you think of just I'll argue by analogy, which I know is dangerous, but you know, when we were trying to get the data from them, what did they say? They said that they would be, they couldn't give us the data now, they didn't know when they could give us the data, and they would give us monthly updates. That sounds pretty good. It was a pretty good kind of thing to come up with in a few minutes, although they had a week to do it. So they came up with that really quickly. And then somebody said that that's unacceptable, and they came up with a completely different story. Oh yeah, we'll give you the data right away. I mean, how can that be? You know, it's like, which lie do you want us to believe? And the problem with the second one is it turned out not to be a lie. They did have the data, and they could give it to us, but they just, you know, a few days earlier told us how they couldn't give us the data. You know, these data are going to take a long time. And, you know, why is that? I mean, what's going on in that? And I think what it is that you're looking for a short-term solution to a serious problem. To give an example, there was a story in today's Globe and Mail, which I happened to read, about a correctional officer who pleaded guilty to a number of sexual assaults of women prisoners in the Atlantic provinces. And so, in a sense, it's a routine kind of unusual, but it's a sexual assault of women prisoners by a male prisoner, by a male officer, and he pleads guilty to it. So that's the story. When Correctional Service of Canada had been asked about the complaints that these women had made to the prison authorities, they said, oh, we turned them over to the police right away. It turned out, you read the story, it's in the Globe and Mail, it turned out it wasn't turned over to the police right away. It was turned over to the police, I can't remember, 3 months later?
Yeah, 3 or 4 months later.
3 or 4 months later, rather than right away. Well, turning it over to the police was a really good answer, except they got caught on it. They got caught on their less than honest answer. Now, maybe it was a mistake, I doubt it, but it might have worked pretty well, except it came out that they had sat on it for 3 months, done their own investigation, and then subsequently decided that they were going to turn it over. Well, why would they do that? You know?
I wondered, thank you all very much. I wondered if you could go back to your second to last slide. Is that possible? I was kind of curious about the way that you analyzed those data. Oh, not the crickets, yeah, this one. The table, sorry, about mental health and its interactions with the length of stay. I wondered why you all chose to look at it where like your bin was, which category they were in as far as mental health, and then putting that across the stays in the way that you did instead of flipped. And that I wondered if you were trying to ask whether prisoners were more likely to have longer stays based on their mental health, and how that interacts with what you all were just saying about like these are difficult people that they're putting in solitary confinement, and then also how that interacts with, you didn't really speak to the grounds that a prisoner can like challenge their stay on for an IEDM, but I wondered about that interaction as well.
Look, this is a, again, if you email one of us, we can give you the report from which this was taken. This is part of a larger table that we have. And the mental health status, as was mentioned, was as you know, assessed by Correctional Service of Canada. And it was their measure of this. The answer, but the more interesting question was later on, which is that the simple answer to your question is we don't know whether the deteriorating mental health was a cause or a result or coincidental with. And I think that it's important to know that. But I think that the problem is if you have somebody who is deteriorating mental health or has a flag on their administrative file saying that they have mental health challenges, that should also be a flag for realizing that this is a problem person that probably SIUs are not the greatest place for. And that our problem is you have somebody who is showing deteriorating mental health, and they're staying in there for a long time. Again, it goes back to my story about the woman who's, I think, from the Arbor Commission, talking about this isn't a really good place for this. But I think the more general point is we don't know whether it's a cause or a result. And I think that that's important. But if it's a result, then it would seem to me this is the result you're not looking for. If it's the cause of putting a person into an SIU for a long time, I'm disturbed, but for different reasons. So.
Well, thank you very much for those presentations. So I'm a believer in the fact that the kind of dysfunction that you've identified is at least as much the result of bad institutional design as it is of bad people. And so a question, I don't know whether you'd answer this question the same way, so a question for both of you individually. If you could identify one institutional structural fix that is both sort of realizable in the real world of politics and that might be effective in diminishing this set of phenomena, what would it be?
Oh, boy, I wish I had the answer.
Yeah, no kidding.
Look, the panel that were, let me not answer your question, but give a reason why I'm not answering it. I think that there are some sort of simplistic notions about, closing these down and so on, and Jane's already talked about that particular problem. I don't know if there's a kind of simple fix for these kinds of things. It seems to me that my starting point, if I had to give one, between now and 20 to 8, it would be that my starting point would be that what we really need to do is to open things up. And that if we open things up, what we might end up with are some creative solutions to problems. I mean, I'm quite disturbed, for example, that one of the solutions from a regional or institutional perspective is to try to move the guy to the next place. And that just seems to me to be an ultimate avoidance of any kind of serious responsibility. But I think what I would try to do would be to say, well, what is it that we could do in this? And my starting point, Jane and I have written about this in each of our reports, and nobody seems to take it terribly seriously, so maybe we don't have anything, but that the regional variation in the operation of of these SIUs is really interesting. I mean, how is it that apparently Ontario can get away with so many fewer placements into the SIUs than Quebec or the Pacific region? Now, it may be that what's happening is that they're being hidden, and that is a serious possibility and a serious problem. That placements, they're not being hidden in SIUs, but solitary is happening somewhere else. And so but I would start by saying, where can we find out about the better way in which these things are operating, and what can we learn from that? I don't know that I can come up with anything better. I don't think that this is an easy thing. Prisons are difficult institutions, and many, but obviously not all, but many prisoners are difficult people to deal with. I mean, they're quite upfront about their own mental health challenges and the difficulty that they have. So I'm afraid that's about the best I can come up with.
Yeah, well, I mean, I certainly don't have any more thorough answers, but I do feel like Correctional Services Canada really takes a cavalier look into, what it has to do and following the rule of law. I think that is shown over and over and over again in court cases, in anything that it's everyone's experience with them. They're defensive, they're not open, they're not transparent. And I think that what may help is if the public safety, which is supposed to be responsible for correctional services, or if that minister, whoever that is, actually took it seriously. And you just think when they did take it seriously, Tony got an immaculate data set in front of him, within weeks, when at that point public safety took the concern seriously and wanted to rectify the situation. So if they have control over this institution, then they need to start taking it more seriously, and they need to care. But no one's going to win votes on this at all. So I don't think any, from the Prime Minister to public safety head, no one wants to touch it because they're not going to get anything from it. If anything, they'll probably lose votes. So I think they just want this all to kind of go away, let it ride, and the best they'll do is nothing. So they're not going to necessarily make it worse, but they don't want to deal with this. So I think you'd need real leadership, and I don't think that exists right now anyway.
That's the optimist.
Yes, thank you again for your very insightful presentation. So consider a person like Larry, to whom I understand he's essentially been subject to what we understand to be torture. And we say that there are no rights without remedies, and prisoners have rights too. What degree of recourse would a person like Larry have when Canada essentially flat out violates its domestic and international obligations?
You've just in your question gone really beyond my knowledge. First of all, I'm not a lawyer, and second is I sort of came into this issue through the back door. But I think that the problem is in our discussions with people who do prison law is it's very, very difficult. I mean, you have factual problems which are very difficult to prove. Think about going to court and you have Larry's account of what happens to him, and you have some administrative data on what happened to him, like what Jane talked about, because that's all from administrative data. We never talked to Larry. But you have the administrative data, but then there are various kinds of reasons. Well, I mean, Jane gave the example of the transfers out don't really have to happen if you were planning on moving him to a different institution. Well, but you look at the data, and the data say that Larry went back, let's imagine that Larry had gone back to the same institution he came from, or that he was in where the SIU was. And they said, oh yes, well, we reclassified him so that we didn't have to move. We decided in the end we didn't have to send him to British Columbia. We decided we could keep him where he was. And how can that be answered? I mean, the problem is, you know, prison law is very difficult. I mean, you have problems at the factual basis, but you also have problems at the sort of expert basis as well, which is, well, we're trying to do our best thing, and we have all of these experts, and it is very difficult. I mean, you know, I'm not embarrassed about not knowing the answer, in part because when we've spoken to Michael Jackson at UBC Law School, who's been working on this literally for 50 years. I mean, he has answers, but you know, he will talk about how certain kinds of things have maybe gotten better. But he doesn't think he's really gotten very far in 50 years, and I think his own writing would suggest that. So, you know, you look for little things that you can do, and but I think it has to be thought of in terms of the larger institution. I keep coming back to both the problem of hiding solitary-like activities in other parts of the institution, but also what you have to look at is what's happening in the rest of the institution that makes the SIUs operate the way they are. I mean, this is not directly on your question, but one of the things which Correctional Service of Canada is quite open about are the problems that they have in getting people out of cells, and also that people want to stay in SIU cells longer than Correctional Service of Canada necessarily wants them to be. And I don't doubt that there are people of both kinds who don't want to leave the cells, even though Correctional Service of Canada offers them something, and don't want to leave the SIU generally because they don't want to go back into the mainstream population. So you can either say that that's the prisoner's problem, or what I would say is, well, what is it about your institutions that makes them so unattractive that people don't want to go back into the normal mainstream population? I mean, if you're not providing the basics in the normal institution, isn't that a problem as well? And I guess this is why I come back to the problem of you have to look at the full institution. And I would start, if I had to be the Commissioner of Correctional Service of Canada, and thank God I don't have to be, what I would want to do would be, I'd start small. I would start with some institution and try to have that be a model of how it could be, and to show everybody including, and perhaps importantly, correctional officers themselves, that this would actually be a better place to work if you didn't have these kinds, if you had a way of solving conflicts. We all have conflicts, but we look for ways to solve them, and maybe what we need is something like that. But I wouldn't start with, they have, I don't know what it is, around 50 different institutions with now 12,500 prisoners in them. I wouldn't start with 12,500 prisoners in 50 institutions. I'd start trying to create model institutions.
Hello, and thank you. This is kind of a follow-up with what you're talking about right now. Did you have access to any kind of metrics for these institutions? For example, are employees given incentives to place prisoners in these SAUs? For example, reducing the number of incidents and that being a measure of that specific prison's performance, and maybe this is incentivizing the correctional officers to place the prisoners within these cells? Thanks.
The simple thing is, I don't think that there are those kinds of incentives. And I think that the panel that I now sit on, that Howard Sapers is chairing, might have access to what's going on at an operational level of the kind of thing that you're thinking about. It's very, my suspicion is that there are real problems in incentivizing people, this is just a suspicion, that they're very difficult, it's very difficult to set up incentives for correctional officers in these kinds of settings, in part, and I don't want to sound anti-union, but in part because of union rules, in terms of what that would actually mean. And so, it's when you talk to people in corrections, they will often talk to you about the problems that they have in accomplishing certain policy goals within the institution. And, I kind of naively, in my mind, is thinking, well, who's boss here? And, the reality is what's going on on the ground is really important. And, I'll just give you a story which doesn't have to do with your answer, but I was in one of the institutions, and I was just chatting with one of the officers who was sort of shepherding us from one place to another. And he said, "Do you know who the most powerful person in this institution is?" And I said, "No, I'll go for that. You tell me who it is." And he said, "It's the person who runs the gates where you go from one long hallway through one gate, and then that gate closes, and then you're held until you can go into the next place." He said, "Because if you piss that person off, or he doesn't like you for some reason or another, he just holds you for some period of time until he decides he's going to let you go. And you say, well, what happened? Well, there was a problem up ahead." And that's all you will ever know. And it's just a little story, but it tells you also about the way in which prisons are run.
Your research has focused on a host of criminal justice issues, and several of your remarks today describe how solitary confinement is the tip of the iceberg in wider problems that appear to be a self-fulfilling prophecy. If people are in overcrowded, mismanaged, violent prisons, this results in the types of problems that arise with solitary confinement. It's not the only factor, but it's part of the equation. In your final remarks, could you draw upon the longer arc of your research and the wider questions you've delved into, and connect that to the issues of solitary confinement, and tie how reforming or abolishing solitary confinement could also be intertwined with a wider vision of penal reform?
In 5 minutes or less.
Just ask a major research paper.
I think, at the moment, to be honest, at the moment, we're working on trying to understand what's going on, excuse me, at a very mundane operational level. At the same time, as I've as we've already said, we understand that you have to get, it has to be looked at in a larger level. And I think the long-term answer is that we really do need to open up the prisons to what's going on, so people actually do understand what's happening at an operational level. I mean, if you think back a number of years now to the inquiry into Ashley Smith's death. I mean, Ashley Smith's death was a series of horrible things that ended with her death. But it didn't start and end on the night in which she committed suicide. It started many, many years later in various ways in which she ended up in the circumstance that she's at. So what you have to do is to say, you know, let's look at the broader picture and let's try to ensure that things like that don't happen in the long term. And let's try to understand that. I mean, we reread the Arbor Commission in large part for this talk. And, you know, going back, I'd been to part of the hearings of the Arbor Commission and in the 90s, and I'd read the report when it came out, and then I reread it after this. And I found it both really important and interesting and informative and incredibly depressing. And the depressing wasn't just the terrible things that happened, but the depressing things were what we tried to capture in our remarks and why we spent so much time on the Arbor Commission, because it just looked so familiar. It's completely different setting. I mean, there are very few women, thank God, in structured intervention units. But what was happening there and the response of CSC was just so familiar to what we were seeing today.
Hi, my name is Julia, and I'm in my first year of law school here. I just have a quick final wrap-up question. Thank you so much for being here. So for all of us here today who just attended this very informative and inspirational speech, more in a practical way, how do you suggest that we quickly pitch to people, this is what I do around the people that I love, friends and family, that we should abolish solitary confinement? How do you suggest pitching that quickly and persuasively? Thank you.
Sure. If I understood your question properly, I think what you have to do is to say that what we want to work on and what you want to abolish are you want to start with the worst things that are happening in the institutions. And you want to start with some part of that and pick away at it. It's not going to happen overnight. You're talking about a big change in an enormous and in a decentralized institution. So you're looking for ways of making incremental changes. I hate talking about it that way, but I guess I'm old enough to say, and you know, I talk to Michael Jackson not very often, but when I do talk to Michael Jackson, all I can think about is how does he maintain the outrage that he has for what's going on after 50 years of seeing this outrage over and over again. And when you go back and look carefully at what he's been trying to do during those 50 years, he's looking for little ways in which things can be made better. And I think that that's the answer. So abolishing solitary confinement as it exists, I'm just worried about that just being it just transferring to various things. I'm worried about that at the moment, let alone if we said, well, you can't have this anymore. So I think you look for those little changes and you look for ways in which can be. I think that for lawyers like Michael Jackson or like the prison lawyers who I know, I mean, they're looking for ways to make things that much better, a little bit better for their clients right now. And they're looking for, they're looking for that small increment. And, maybe that's, through court cases, it may be through other kinds of ways. I don't know. I mean, these are very difficult things. It's how do you change? I mean, you're asking, my background is, as a social psychologist and then a criminologist, and what you're asking me to do and legitimately asking me to do, is to think about this from a kind of large organization perspective. How do you change organizational culture? And that's, I think, what we're talking about. And, I guess this is why I keep coming back to, I wouldn't start with everybody. I would start small and work up.
And if you're thinking about how to persuade people, like friends and family, I think you had mentioned about, that solitary should be abolished, and we should, I think it's important to remember that the vast majority of these people are coming out, and I don't think it's in anyone's interest to have them go from these sorts of environments to our streets. It serves no one's interest except possibly administratively for CSC. So for public safety reasons, even, it's in no one's interest to treat people like this. It's making it worse.
Merci mille fois. Thank you so much. Je veux encore remercier la famille Proulx pour son soutien à cet événement, ainsi que le doyen Robert Leckey. Merci à vous tous, vous toutes d'être ici ce soir. And remember, where there's life, there's hope.